আপনাদের সকলকে আমি আবারও আমন্ত্রণ জানাচ্ছি আজকের ক্রিমিনাল লয়ের উপর এই আইন বিষয়ক অনুষ্ঠান ক্রিমিনাল জাস্টিস প্রোগ্রাম দেখবার জন্য। আমার সাথে ছবিতে যেটা দেখছেন সে হলো প্রেস্টন ক্রাউন কোর্টের জাজ, তার নাম হলো জাজ রবার্ট অলথাম। সে পানিশমেন্ট দিচ্ছিল, সেন্টেন্সিং রিমার্ক করছিল একটা, তখন তার বয়স ছিল 22 বছর মেয়েকে। সে মিথ্যা অভিযোগ করেছিল পুলিশের কাছে, অনেকগুলো অভিযোগ যে তাকে রেপ এবং সেক্সুয়াল অ্যাসল্টের জন্য এশিয়ান গ্যাংরা তাকে গ্রুমিং করেছে, তাকে বিভিন্নভাবে প্রলোভন দেখাইয়ে তাকে অ্যাসল্ট এবং অ্যাবিউজ করেছে। এগুলো ছিল সবগুলোই প্রায় মিথ্যা। এবং জাজ বলছিল, আপনারা শুনছেন একের পর এক অনেকগুলো বলছে কি কি কথাগুলো সে পুলিশের কথা বলছে, এবং জাজ বলছে এটা ঠিক না, এটা ডাহা মিথ্যা। এবং যেই বিজনেসম্যান, এশিয়ান ম্যান, ওরা নাম প্রকাশ করতে ইচ্ছুক ছিল না, ওরা বলছে কি তার বিরুদ্ধে এলিগেশন করা হয়েছিল, তাকে ট্রাফিকিং করা হয়েছিল, তাকে ট্রাফিকড তাকে মেয়েটাকে। সে কোর্টকে এই কথা বলছিল এবং ওই লোক বলছে কি, বিজনেসম্যান যার বিরুদ্ধে অভিযোগ করছিল, I have had countless death threats made over social media from people all over the world because of what they thought I was involved in. সে বলছে কি, পৃথিবীর বিভিন্ন দেশ থেকে তার কাছে সোশ্যাল মিডিয়ার মাধ্যমে অনেক অগণিত কাউন্টলেস থ্রেট, হুমকি আসছিল কিল করার জন্য। তাকে বিভিন্নভাবে হুমকি দেওয়া হয়েছিল। এই বিভিন্ন হুমকিগুলো আসছিল বিভিন্ন দেশ থেকে, ওয়ার্ল্ডের, এবং তারা মনে করছিল কি সে এই মেয়েটাকে অ্যাবিউজ করেছে। তার বয়স ছিল তখন 43 বছর, 43 ইয়ার্স। বলছে কি, মেয়েটা বলছে কি, এই লোক had groomed her from the age of 12. বলছে কি তার বয়স যখন 12 বছর ছিল তখন থেকে তাকে গ্রুমিং করেছিল এই মেয়েটাকে, ওই লোকটা। put her to work in brothels in Amsterdam. বলছে কি আমাকে একটা ব্রথেলস, যে পতিতালয়ের মধ্যে আমাকে কাজ করতে দিয়েছিল আমস্টারডামে, and sold her at an auction there, এবং তাকে বিক্রি করেছিল একটা অকশনের মধ্যে। এই কথাও সে বলছিল পুলিশের কাছে। But the court heard that, কিন্তু কোর্ট শুনছিল কি, the time she was in Netherlands, his bank card was being used at a B&Q in Baro. এবং সে যখন নেদারল্যান্ডে ছিল তখন তখন তার ব্যাংক কার্ড B&Qতে ইউজ করা হয়েছিল ভারতে, ওই একটা এলাকা ইংল্যান্ডের মধ্যে। সুতরাং এটা সত্য না, এটা হলো মিথ্যা কথা। আরো অনেকগুলো জাজের মুখেই শুনবেন এখন, বলছে কতগুলো মিথ্যা সে বলছে। আমি কন্ট্রোল রুমকে বলছি, আপনারা প্লিজ জাজের এই স্পিচের বাকি অংশটুকু এখন প্লে করেন।
Since she has been found guilty, the defendant has hinted at other sources of trauma, but has given no real indication as to what it could be. Of course, I've considered whether the aberrant nature of these offences means that I should assume that the defendant is suffering from some mental impairment. There is no explanation for why the defendant would commit these offences. She has gone to extraordinary lengths to create false accusations, including causing herself significant injury. No explanation for this behaviour is apparent. However, that does not mean that I should speculate. Unless and until the defendant chooses to say why she has told these lies, we will not know. In any event, I question the relevance of the defendant suffering from a complex post-traumatic stress disorder in relation to sentence. When Dr. Bacon gave evidence yesterday, I asked her to comment on whether such a condition could reduce the culpability of a person to be sentenced for perverting the course of justice. Dr. Bacon had told us that this was not within the scope of her instruction from the defence. When I asked the question of Dr. Bacon, Ms. Blackwell, KC, intervened, telling me it was not the defence case, that the defendant's complex post-traumatic distress disorder, if that is what she has, is relevant to culpability. I do accept that it is part of her personal mitigation that she has vulnerabilities that I will take into account. I turn to the structure of the sentence. The count which concerns C and the counts which concern Mr. Trencove are separate from each other and from the other offending in this case. However, the offending at counts 5, 6 and 7 can properly be regarded as a course of conduct. Counts 8 and 9 are together part of the same course of conduct, and whilst they could be seen as part of that represented by counts 5, 6 and 7, they concern a separate incident and were committed on bail for other matters. I intend to impose concurrent sentences on counts 5, 6 and 7. However, there will be a consecutive sentence on count 1. There will be additional sentences on counts 2, 3 and 4, concurrent with each other, but consecutive with the other sentences. There will be further sentences on counts 8 and 9, concurrent with each other, but consecutive to the other sentences, save that I will temper the structure of these sentences to give effect to totality. There is no guideline for this offence, and I apply the general guidelines overarching principles. The maximum sentence is at large. I've been provided with a number of authorities which I've read. There are no analogous offences for which there are guidelines. I consider first the defendant's culpability, then the harm. I consider the purposes of sentencing, and then the aggravating and mitigating features. I must then consider totality before arriving at my final sentence. The cases to which I've been referred provide the following factors, which are amongst those that I should bear in mind. I remind myself that because this offence strikes at the heart of the administration of justice, it is to be regarded as serious. Deterrence is an important aim of sentencing, though I must remember that when sentencing young people, this may be extinguished or diminished, where the principal aim of the youth justice system is to prevent offending by young people, and I must have regard to the welfare of the defendant. This offence is fact-specific. Previous cases are of little assistance. When considering culpability, I must take account of the seriousness of the underlying offence. I bear in mind the nature of the deceptive conduct and the time over which it continued. I consider whether the offence cast suspicion on others, whether others were arrested. In this case, I'm asked to consider community impact. I'll set out in detail my approach in this regard. In relation to all counts, I bear in mind that these were allegations of sexual offences. These carry not only the risk of prosecution, but also a potentially indelible stain on the character and reputation of everyone accused. Sexual allegations, even where disproved, often leave the falsely accused person living under a general and misplaced suspicion. I consider culpability and harm. In count 1, the culpability is high. The allegation was very serious. However, the defendant withdrew her support for the prosecution of C after 2 months. The harm is also high. In his victim personal statement, C sets out how frightening it was to be wrongly accused and then arrested and kept in the police station. He had to remove himself from social media because he was wrongly accused of being a rapist. Even 5 years later, he says he doesn't go to Barrow Town Centre because he fears he's under suspicion. He couldn't even bring himself to pick up his son from nursery for fear of what people were saying. He describes the defendant's false allegations against him as the worst experience of his life. He does not think he will ever recover. In relation to counts 2 to 4, the culpability is higher still. The allegations were even more serious, and there were a number of them. They were maintained over a longer period. They were bolstered by the creation of false evidence with some degree of sophistication. The harm is also even higher than in count 1. Mr. Trengove's house was spray painted with the word rapist. His mother had to leave her house. He was remanded into custody between May and August 2019. Even when released on bail conditions, he had to live far from home for a further 19 days. When he returned to Barrow, he was abused on the street by strangers. He became isolated. He tried to take his life in August 2020 and is still taking antidepressant medication. He lost any sense of self-confidence. He says he can no longer work. He has a child now, and social services received scores of anonymous phone calls saying he is a rapist and not safe to be with his child. He recently moved house, and a neighbour called him a rapist, saying they didn't want him living there. The culpability in relation to counts 5, 6 and 7 could hardly be higher. The allegations made were of the utmost severity. They were made over a protracted period. There was considerable sophistication in the creation of false evidence to support them. The harm in relation to these counts is extremely high. Mr. Ramzan was arrested on the 7th of July 2019 in the public street in the community where he lives, and then held in custody for 36 hours. 2 weeks after his arrest, he was in such despair that he tried to kill himself in front of his family in a most graphic and upsetting way. He sustained injury in that attempt, which has left scars. Though he was informed the next month that there will be no further action by the police, that was, as he puts it in his statement, only the start of the worst period of his life. He then describes being targeted by sections of the Barrow community. He's been unable to sleep, and to this day fears for his safety. The windows of his vehicles have been smashed and their tyres damaged. He and his family have had to endure abuse. The windows of his rental property have been put in and then, once repaired, immediately put in again. He's received countless death threats over social media. He's felt anxious going out for the last 3 years. His family, including his children, have been affected. For a period they had to move out of the family home. He describes the trauma of being cross-examined in court during the trial. His businesses were ruined. He describes going from a successful businessman to someone who has virtually nothing. Also in consideration of harm is the young man who happened to meet the defendant in Preston on the 18th of July 2019 on the way back from Leeds. When he was told that he'd been accused of raping the defendant, he suffered serious consequences. He tells me in his statement that he was studying for professional exams and doing well at work. As a result of this allegation, he was unable to continue his studies and hasn't worked since. He tells me he suffered a serious crisis in his mental health. He attempted to kill himself. Though the tone of his statement suggests that this false allegation was not the only cause of these problems, it is his belief that they significantly contributed to them. He remained anxious about going out and meeting people. He doesn't trust people. He found the trial itself very stressful. Since then, he has started to feel better. I turn to the statements of those who were wrongly identified as being the victims of exploitation. Their names may not be reported. They all refer to the surprise of being approached by the police about matters of which they knew nothing. One then refers to particular problems she had, as she was pregnant at the time she was spoken to, and particular problems which followed. Another speaks of her feelings at having been, as she puts it, exploited by this defendant. Another speaks of the disruption of being required to give evidence at court at a particularly inconvenient time in her life. I now turn to the question of community impact. Under Section 63 of the Sentencing Act 2020, I must consider the harm which the defendant intended and that which might foreseeably have been caused. I've seen statements in relation to this topic and viewed a compilation of footage taken at the time. According to the statement of Superintendent Pearman, the period following the Facebook post on the 20th of May 2020 was turbulent in Barrow. He says that Barrow had not seen such a public display of anger for 30 years. There were public demonstrations targeting the local paper, the local Asian community, and the police. This was in the height of the first lockdown, and Superintendent Pearman tells me in his statement that there was a sense of heightened tension for about 4 months. The comments attracted by the defendant's post named local businesses who feared they'd be subject to attack. One restaurant had its windows smashed. Police resources were diverted to dealing with the threat. Death threats were made against local restaurant owners. Marches were organised to protest about a suspected police cover-up. The arrest continued until the August of 2019. Local people felt motivated to donate their money to a fund which was set up to support this defendant. This fund quickly reached £22,000. What effect, if any, should this have on the sentence of the defendant? During the course of this trial, I've heard many days of evidence from this defendant and have read hundreds of her social media communications. It is not the Crown's case that when she blamed Asian and Pakistani men for her abuse, she was racially motivated. I agree with that position and will sentence on the basis that she was not so motivated. I note that in this case she has made false allegations about white men also. I'm sure she chose to lie about Asian men because she was modelling her lies on other cases of national prominence. She regarded the prospects of being believed as greater if she based them on true cases already within the public consciousness. She was not principally motivated by a desire to stir up public unrest. However, I cannot conclude that she chose to make her Facebook post of the 20th of May 2020 for any other reason than that she intended to create an impact within the town. I accept that there was no direct incitement to do anything, but it was entirely foreseeable that there will be considerable community impact upon those of Asian or Pakistani heritage. She cannot be held wholly or directly responsible for the criminal behaviour of others who used her allegations as an excuse for their own inexcusable conduct, but it was foreseeable that others would behave in antisocial and unacceptable ways. It was not foreseeable that her cause would be taken up by those outside Barrow and developed to the extent that it did. However, some community impact was foreseeable. To that limited extent, I take into account the community impact. The harm of this offending extends to an undermining of public confidence in the criminal justice system. We are aware that sex trafficking of young females does occur. There is a risk that genuine victims will, as a result of this defendant's actions, feel deterred from reporting it. People may be less likely to believe their allegations. I'm sure that those charged with investigating such offences will do all in their power to avoid any reluctance to investigate such allegations. In this case, I make reduction for the defendant's age, then for personal mitigation. In relation to count 9 only, I reduce the sentence for credit for a guilty plea. I then further adjust the sentences for totality. To assist in understanding how I've arrived at my overall sentence, I first set out the sentences after trial for each count without applying any reduction for any of these factors. In relation to count 1, the sentence would have been 2 years imprisonment. For counts 2, 3 and 4, 5 years imprisonment, concurrent with each other, but consecutive to the sentence on count 1. For counts 5, 6 and 7, 7.5 years imprisonment, concurrent with each other, but consecutive to the sentences already imposed. For count 8, 2 years imprisonment, and for count 9, 1 year and 4 months imprisonment, both consecutive to the sentences already imposed. I then turn to the various reductions for the factors mentioned above. The defendant was a child when she committed the offence at count 1. The relevant guideline indicates that the court should take as its starting point the sentence likely to have been imposed on the date at which the offence was committed. That sentence would have been, if custodial, a detention and training order of less than 2 years. The reduction from the adult sentence will be 1/2 for count 1. In relation to the other counts, the reduction for age will be of the order of 1/4. There will be a reduction for age of 1/3 from the adult sentence in relation to counts 2 to 4. In relation to the other counts, the reduction for age will be of the order of 1/4. She was 19 during much of this offending. After her false allegations about Mr. Trengove, this was not impulsive offending arising from naivety. That explains the lesser reduction. I then, concurrent with one another, but consecutive to the sentences already imposed. Finally, there will be a sentence of 1 year and 3 months imprisonment on count 8 and 6 months imprisonment on count 9. Those sentences to run concurrently with each other and the other sentences imposed. That gives a total sentence of 8.5 years imprisonment. You will serve half of the total sentence of imprisonment in custody, after which you will be released on licence. The days spent in custody will count towards your sentence. You've spent 361 days on a qualifying curfew. Because of that, the time you must spend in custody is reduced by 179 days. If that figure is incorrect, it can be corrected later without a further hearing. On release, your licence will be subject to conditions. If you breach the terms of your licence, you'll be liable to be recalled to serve the remainder of the sentence. There is an application for a serious crime prevention order. I find that this is a serious offence for the purposes of this application. There are reasonable grounds for believing that the order will protect the public. I exercise my discretion in favour of making the order as sought, with amendments to the effect that she may also possess a tablet and games console, and that you may also be able to operate a work and a personal email. That order will run for a period of 5 years from the 17th of February 2025. I order
দর্শক, আপনারা শুনছেন প্রেস্টন ক্রাউন কোর্টের জাজ স্পিচ দিচ্ছিল। সে অনেক বছরের সাজা দিয়েছে এবং সে অনেকগুলো একটার পর একটা বলে যাচ্ছিল কিভাবে সে এই লাস্ট এই যে লং সেন্টেন্সে কিভাবে উপনীত হয়েছে। সেখানে আপনারা শুনছেন জাজ দুইটা ওয়ার্ড ইউজ করেছে, একটা হলো কনকারেন্ট আর একটা হলো কনসেকিউটিভ সেন্টেন্স। এইটা হচ্ছে কি, মনে করেন একজনকে যদি 7, 8, 9 বছরের 7 বছরের জন্য সাজা দিলে একটা অপরাধের জন্য, আরেকটার জন্য 8 বছরের জন্য, আরেকটার জন্য 9 বছরের জন্য, কনকারেন্ট মানে সবগুলো একসাথে আপনার মানে সেন্টেন্সটা সার্ভ করবে সে। তার মানে সর্বোচ্চ যেটা 9 বছর, ওই 9 বছরটায় থাকতে হবে। 7 বছর 8 বছর ওই দুইটা ও কিন্তু একই সাথে শেষ হয়ে যাবে। আর কনসেকিউটিভ হচ্ছে কি, একটা শেষ হওয়ার পরে আরেকটা শুরু হবে। 7 বছর শেষ হওয়ার পরে তারপরে শুরু হবে 8 বছর, 8 বছর শেষ হওয়ার পরে শুরু হবে আবার 9 বছর। তার মানে টোটাল 25 ইয়ার্স, 7, 8 আর 9, 24 ইয়ার্স। এটা হলো কনসেকিউটিভ সেন্টেন্স, মানে একটার পর একটা সবগুলোই সার্ভ করতে হবে, টোটাল 24 ইয়ার্স। আর কনকারেন্ট হলে একসাথে সবগুলো শেষ হবে। দর্শক, আজ আমার সময় শেষ হয়ে গেছে। আপনারা এটা প্রোগ্রামটা আবার কাল দেখবেন সকাল 9:30 থেকে 11টা পর্যন্ত এনটিভির আপনার টেলিভিশনের মধ্যে। তাছাড়া এনটিভি ইউরোপের ফেসবুক, ইউটিউব, টুইটারে লগ ইন করলেও আপনারা প্রোগ্রামের লিঙ্ক পাবেন। আপনারা এই ভিডিওটা দেখার চেষ্টা করবেন, কারণ এখানে অনেক কিছু শোনার আছে, অনেক কিছু জানার আছে। জাজের স্পিচের মধ্যে সে একটার পর একটা অনেকগুলো ঘটনা সে আপনার লিস্ট করেছে, কিভাবে কিভাবে কতগুলো মিথ্যা বলেছে, প্রত্যেকটা সে একটার পর একটা বলে গেছে এই প্রায় ঘন্টা খানিকের মতো এই ভিডিওর মধ্যে। এই জন্য এটা অনেকের জন্য গুরুত্বপূর্ণ এবং আজকে আমাকে এখানেই শেষ করতে হচ্ছে। আর আজকের প্রোগ্রামটা আমি আগে বলছি, আপনারা কাল আবার সকাল 9:30 থেকে 11টা পর্যন্ত এনটিভিতে দেখবেন। সবাই ভালো থাকুন, সুস্থ থাকুন এবং সকলের প্রতি আমার শুভকামনা থাকলো। আসসালামু আলাইকুম।